Thank you. Please be seated.
All right, good morning, everyone. We'll go on the record on these matters. Case CR 22-211623, State of Idaho versus Chad Guy Daybell. Mr. Daybell is here present in court, represented by his attorney, John Pryor. Also before the court, case CR 22-211624, State versus Lori Noreen Vallow Daybell. She is here represented.
That I be provided some DNA evidence. I do not have that evidence. And I could really care less whether the state thinks it's exculpatory or not. It doesn't matter what they think, and I could care less what they think. But I'm concerned about what I think. And if I think that evidence is exculpatory, I'm entitled to it. And I'm entitled not only to have that evidence, I'm entitled to test that evidence and have an adequate amount of time to do so. And they don't get to dictate and one-sided, and we've been through this before, and I didn't want to turn into this kind of a tone, Judge, but we've been down this road before. They don't get to dictate what's exculpatory and what I want to use in my case.
No, they don't.
The only thing they're entitled to is I'm going to show them what evidence I'm going to use. That's what they're entitled to, and they're going to get that. But until they get those reports and the expert reports that I have to prepare, I want the evidence. I want the evidence. I want my expert to have an adequate amount of time to test it. And Ms. Blake brought this up. In both of those DNA cases, Judge, I entered into a stipulation that allowed their expert to test the evidence.
That we're not having the jury sequestered for lengthy periods of time so that the court can rehash all of this stuff that we're arguing today. Thank you.
All right, thank you, Mr. Thomas, for the argument. Who's responding for the state?
I am, Your Honor.
All right, Mr. Wood, if you'd like to respond, you may.
Thank you. I would again just incorporate the record that we've made and proceed to the substantive portion of the motion. There is a very distinct difference between the cases cited, Edmund and Tyson, and the case before the court. And it boils down to the word intent.
Yeah, what's your intent?
Felony murder is a very different crime.
Did you commit these crimes?
Conspiracy to commit murder.
Because I'm innocent.
Premeditated murder. Edmund is a perfect example of that. You have an individual
whose
job was essentially to drive a getaway car, was separated from the murder, had no idea that was going to happen.
I just don't like him. He lies. I think he was involved.
Was not the one who pulled the trigger. He's attenuated enough from the murder that while he's liable for
liable.
He can't be executed. The real rule that comes out of Edmund is that punishment must be tailored to the defendant's personal responsibility and moral guilt. There's no pronged test.
I have no morals.
That applies to every case that comes out of Edmund. That doesn't exist. Tyson stands even further for that proposition that
whatever you say, Wood.
It's got to be it's got to be tailored to the personal responsibility of the individual. And in Tyson,
I'm not responsible.
The individuals who were convicted of felony murder. The real rule that comes out of Edmund is that punishment must be tailored to the defendant's personal responsibility and moral guilt.
I'm not responsible.
There's no pronged test that applies to every case that comes out of Edmund. That doesn't exist. Tyson stands even further for that proposition. That,
what do I got to listen? All I hear is
it's got to be it's got to be tailored to the personal responsibility of the individual. And in Tyson, the individuals who were convicted of felony murder were close enough and acted with such utter disregard for human life that death penalty was appropriate.
I will.
And yet,
your life a living hell.
I'm sitting here discussing those cases. They really aren't applicable. Mrs. Daybell is not charged with felony murder. She's not charged with the death of her children and Tammy Daybell in furtherance of another felony. She's charged with conspiracy to commit murder. I'm not going to get into the evidence of the case.
No, don't.
It suffices to say that the grand jury has found probable cause. That she did commit these crimes.
I did not.
And I certainly understand the defense is not going to come in here and admit that.
What's there to
There
admit?
has been a probable cause finding by a grand
I'm
jury
not
she committed
guilty.
these crimes.
Okay, what?
The state has
I
complied
can't
with
stand you.
the
20 days ago, 3 weeks ago. And we entered into, again, a stipulation in an order that allows them to test it, and on their schedule, get me the report so that I can follow up and do my own testing, and then get a report.
He's mad.
And I don't care what they say. I'm entitled
We
to
don't
all
care.
evidence and
We
make my
don't
own
care.
adequate determination as to whether it's exculpatory or not.
No, he's
And they
not my
can't
attorney,
tell
but
me when I'm going
he's
to
my
get the
husband.
evidence. And I'm not going to sit here and say, well, you got me the evidence and you decided that
I'm
it
not
wasn't
gonna sit here
important
either.
enough. That's not the way this works.
I'm
I
gonna
want
spin
the
around in my
evidence.
chair.
I want time to be able to test it. I want time to be able to issue a report. And I want time to be able to prepare for trial. And you're asking me to do that in the next 9.5 weeks, and they haven't even got me the evidence
That's
yet.
right.
And
Tell
I
him.
disagree wholeheartedly with Ms.
Go,
Blake.
Johnny boy. Go.
Quite frankly, you don't get me the evidence,
That's right.
and I don't do
What
an
he
adequate
said.
job.
And the death penalty should not be up to a local prosecutor. It should be narrowed by the Idaho legislature, not just left up to
Yeah,
a local
he's been
prosecutor.
drinking. Can you tell?
And
He's
so we
learning.
find
He learns.
that this narrowing requirement is required
In fact, the
by
council.
the Constitution
He's been drinking.
does not apply to this case. What have they filed against Lori Vallow Daybell? They've included allegations that she killed for money, that she killed in an especially heinous, atrocious,
I
or
didn't do
cruel
nothing.
manner, manifesting exceptional depravity, that she killed in circumstances
I didn't kill
which
nobody.
exhibited utter disregard for human life, or that she killed which exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. So the local
did a big threat.
prosecutor is asking a jury in
I
Ada
did.
County that if they find one or more of these aggravating factors, that she's eligible for the death penalty. That broad list of aggravators is not narrowed. And the constitutional requirement that we narrow down
No, come
death
on.
cases to the worst
Just
of
say
the
you're not
worst.
going to kill her.
And this
Because I'm too pretty.
in this case, there's no
That's sweet.
narrowing at all. And so because the local prosecutor, will she really be killed? History
No, I
says no. So we're pursuing a punishment
Because I'm
that
innocent.
will not happen. And how do I know
I'm going
that?
to be free, people.
Because of who's on death row right now in Idaho.
Let's not get into that.
I'll go alpha, basically a license to kill. So that's what this death penalty motion is about, Your Honor.
All right, thank you, Mr. Archibald. What's the state's response?
Thank you, Your Honor. Lindsay Blake for the state.
I can't stand her.
When we look at the motion that was filed, and I respect and understand what Mr. Archibald's saying, that this is a fairly standard motion that's filed in death penalty cases. The state's first observation or position would be
Protection of clients, the Sixth Amendment, the Eighth Amendment, the 14th Amendment to the Constitution. As indicated, there's been studies, and the death penalty should not be up to a local prosecutor. It should be narrowed by
Especially
the Idaho
Rob Wood.
legislature, not just left up
That's right.
to a local prosecutor. And so we find that this narrowing requirement is required by the Constitution,
Constitution.
does not apply
I have rights.
to this case. What have they filed against Lori Vallow Daybell?
That's me.
They've included allegations that she killed for money, that she
No, I
killed in an especially heinous, atrocious, or cruel manner,
I didn't do
manifesting exceptional depravity, that she killed in circumstances which exhibited utter disregard for human life, or that she killed which exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. So the local prosecutor is asking a jury in Ada County
Can't stand
that
him.
if they find one or more of these aggravating factors that she's eligible for the death penalty.
Oh, it's
That
gonna kill me.
broad list of
The prophet.
aggravators
The true
is not narrowed.
Only prophet.
And the
told me.
constitutional requirement that we
Yeah.
narrow down death cases to the worst of the worst. And this,
The worst.
in this case,
I've seen
there's
worse.
no narrowing at all.
Yeah.
And so because the local prosecutor is given
Ragwood.
the discretion, it does not satisfy
No.
the constitutional requirement.
No, it doesn't.
And
Come on,
and in her
spit it out.
study,
It's been drinking.
she
In
goes
fact, the
through all
counsel-
the Idaho cases
drinking.
where the death penalty could be filed, the death penalty was filed, or the death penalty was not filed. And my experience, I point out in my motion, is similar to Professor Cover's study. That is, be charged with the death penalty. 9 of them were charged. Of the 9 that were charged with the death penalty, 1 received it.
I know, spit it out.
And
He's
that
been
one
drinking.
who received the
Ineffective
death
counsel.
penalty was Timothy Dunlap, of whom I was assigned to represent some 14 years after his crime. And so how does it happen that I am assigned to represent someone 14 years later after he's already been on death row 14 years? Because of the appeal process. Because if Idaho is successful in getting a jury to kill Lori Daybell, will she
one's
really
gonna
be
kill me.
killed?
No.
History says no.
No.
So we're pursuing
kill me?
a punishment that will not happen.
No.
And how do I know that?
I'm innocent.
Because of who's on death row right now in Idaho. Yeah.
You tell him.
Ask the court to not rule that these motions are not right. We'd ask the court to rule substantively on the motions so that if we do have to bring them up again at the end of the guilt phase, that we're not having the jury sequestered for lengthy periods of time so that the court can rehash all of this stuff that we're arguing today. Thank you.
All right, thank you, Mr. Thomas, for the argument. Who's responding for the state?
I have, Your Honor.
All right, Mr. Wood, if you'd like to respond, you may.
I can't stand that guy.
Thank you.
I can't stand him.
I would again just incorporate the right that we've made
He doesn't know how to shut up.
and proceed to the substantive portion of the motion. There is a very distinct difference between the cases cited, Edmund and Tyson.
Yeah, because I'm innocent.
And the case before the court. And it boils down to the word intent.
Hurry up.
Felony murder
Shut
is a
up.
very different crime than
Lori, do you love Chad?
Yes, I do. Yes, I do. I love you, babe. Hi, Nate. How are you? Oh, you did try to come earlier? What happened? Oh, I was in the hall. It's your fault. Your crew. They asked me if I love Chad. I said, yeah. Yes, I do. Yes, I do. It's okay, though. It's okay. I'm glad they let you come back. Did you get your books yet? You did? Well, I got a surprise for you. I'm gonna give you these. Yeah, these are from me. Okay? Edge of heaven, yes. Been living on the edge. See, I've been a little crazy lately because people have been sending me music on my tablet. And I think it's that girl from YouTube. And then The Great Gathering. Because we're all gatherers. Yeah. So, what would you like to talk about? No, I don't want to talk about that. I want to talk about Chad? I know he looks straight ahead. Well, why? Because it's our master plan. Oh, he'll never divorce me, ever. No, because I'm the queen. 10444. Yeah. Okay. Talk to you later. Bye. Love you, fans. Love you. Love the world. The world.